Good day all and welcome to Obidati Family TV. The program na Hope Alive. Yes, hope day and plenty hope day. Some people they think say after the rigmarole wey they do yesterday, say hope no day again. We don't come out today, hope day. Because as our own principal, Mr. Peter Obi don't talk, His Excellency, the lawyers don't come out. Carry the amount talk say they were directed to proceed to Supreme Court. That one na their own. Then they go Supreme Court. And now matter then they carry go. Make una know say no be Peter Obi na in choose us. Now all of us choose Peter Obi. Wherever on a day, on a good morning, afternoon, and evening. Welcome. Now, the thing wey happen yesterday, now we won't talk. And we won't break and down, summarize them, and bring our own where we dey go. But first, I no go fail to bring the wetin the party and Peter Obi bring for about this judgment. They say the Labour Party watched with dismay the dismissal of petition by the 5-man panel of the Presidential Election Petition Court led by Justice Haruna Samani and we reject the outcome of the judgment in its entirety because justice was not served and it did not reflect the law and the desire of the people. Nigerians were witnesses to the electoral robbery that took place on February 25, 2023, which was globally condemned, but the tribunal in its wisdom supposed to say refused to accept the obvious. What is at stake is democracy, and we will not relent until the people will prevail. We salute the doggedness of our team of lawyers who fearlessly expose the rot in our system. We can only weep for democracy in Nigeria, but we refuse to give up on Nigeria. Well, details of the party's position will be presented after consultation with our lawyers, and the certified true copy of the judgment is made available to the team. When Peter Obi and the team gets the main certified true copy of all this talk wey pass from morning till night, all the grammar and the lie wey plenty for their mouth that yesterday, then go compile them together, then go waka go Supreme Court. Now for the analysis and summary of all the hours wey dem consume to talk the lie wey full their mouth, wey dem call justice. Now that one go bring come, and we get our own analysis where we don already put together through our own UC Maxwell. We go join us through Zoom. In go break and down, make we understand, and also show where we are headed. For inside studio here, I know they alone. I deal with Angel, I get Princess and Esther. Make we start from studio.
Good day, my well-meaning Nigerians, my lovely and intelligent, obedient worldwide. Tell your neighbor, say, we never lose hope. Even though, say, we still there for shock. Even me, the shock will never leave me. I know, say, some of una, the shock still there your body. But you no go lose hope. As they don't disgrace themselves yesterday, no wahala. We dey, because I know, say, their conscience no dey clean. And it no dey clear. Because I wonder how they go look back 10 years to come and look at this judgment where they give yesterday. How will they feel? Welcome on board. Let's discuss.
Yeah, so well-meaning Nigerians and fellow obedience, my people, una welcome. See, the journey of this battle for a new Nigeria, it never stop. Oh, it has just begun. My people, it's not going to be a walk in the park. So let us brace up and take back our stolen mandate. Welcome on board. Let's discuss.
To my well-meaning Nigerians and fellow obedient worldwide, good day to you all. We are not slaves in our own country, but citizens. And so we cannot be living like refugees in our own country. Whatever happened yesterday, they did it to dissuade us. But no, we'll only pick up the fight and persuade ourselves and increase as we keep our hope alive. So welcome on Hope Alive.
Yes, welcome to Hope Alive. The hope still there. And waiting in the top, we say it is not yet over until it's over. See, if to say these people do the right thing yesterday, una foresee jubilation for Nigeria. Una go foresee how even people will be said in the beg for road. Una go see the kind happiness we go they dwell inside them. We know all these things. But anyway, make we go straight to the summary of all the things where these people talk. Because yesterday, as una know, Obidate Family TV stay from morning till night. The whole hours where they sit down for that very place, we dey there, we dey stream am live. Everything where they talk for inside there. Any thing where we say cough, we come out from there, we collect them. And we get our own Maxwell for inside the court, outside the court, taking everything we say they enter, plus interviews we say grand there, we go show now all of these things. But first, make we begin to go through to the 3 petitions we say they deal with yesterday. First, they deal with APM own. And that APM own are Allied People's Movement. How they take scatter that matter, we'll go to our analyst where we say, there for Zoom. Maxwell, make you begin to help us to digest this very thing from APM, make we end, make we forgive our people. The summarized version of what happened yesterday, and then we'll enter to the main thing where we say where we won't go, where we are headed. As our lawyers don't talk, say, then get direction to go to Supreme Court. And we go bring the video where they take talk and how they take talk. But make we start with this one. Maxwell, you have the mic.
Okay, thank you very much. Good afternoon to you, Mr. Kanu. Good afternoon to all my friends and family members by virtue of the obedience movement. To each and every one of you in the studio. Obedience worldwide, well-meaning Nigerians, wherever you may be hearing my voices from. I bring you good tidings, and of course, I bring you happiness. Well, it is unfortunate that we had to go through the torture yesterday, which ended up being a torture in futility. We went through the entire torture for nothing. Yesterday was a day, 6th of September 2023, where justice was sold on the altar of corruption. Justice was sold on the altar of bias. Justice was sold on the altar of men who have decided to trade our society for their personal pockets. Moving straight into the APM petition, the APM had approached the court questioning the election of Bola Tinubu and Kashim Shettima. In that case, there were 5 respondents to the case. INEC was a respondent, Tinubu was a respondent, Shettima was a respondent, the APC was a respondent, and again, Aminu Masari was a respondent. Now, recall that prior to elections, sometime in July, June, July of 2022, Bola Ahmed Tinubu had announced that Aminu Masari was going to be his running mate. Then later on, he decided to change Aminu Masari from being his running mate and chose Shettima. Now, producer, I don't know whether you have the Electoral Act there close to you. Maybe you can project it for us. Section 33 of the Electoral Act, all the provisions there within also Section 30, 31, 32, but particularly Section 33. Now, they had questioned the timing for which a person have to withdraw a candidate. Now, the provision of the law states that for you to be able to make a withdrawal, for you to be able to change a candidate in an election, that it is only on 2 grounds. And the first ground is that such a person must have died, meaning that you cannot change a candidate except the candidate have died, then you can now provide another one. Then the second ground is that the person who is the candidate will voluntarily withdraw from candidacy, and there is a procedure before a withdrawal will be deemed to have been concluded. By virtue of that provision of the law, it states that the candidate shall write a letter expressing his intention to withdraw from the race. He shall have that letter submitted to the party, and it does not stop there, that the political party will proceed to notify INEC. That is, they will tell INEC, they will show INEC this intention to withdraw. Then they will now submit the new name of the candidate. So it was on this basis that APM took their case to court. They also stated that on the basis of double or multiple nomination, that there is no need of timing. On the basis that if a person has held candidacy during an election period for a particular party or for a particular constituency, that the person cannot subsequently be a candidate in another constituency or in another party's election. Now, to the first ground I told you of withdrawal, there is a 14 days period for a person to withdraw, and then the appointment of another person. What does this mean? That when Aminu Masar decided to withdraw his vice presidential candidacy, you have a 14 days period for the party to change the person. Now, APM told the court that the 14 days was not adhered to. It means that from the time which Aminu Masari declined or withdrew his candidacy, it lasted for more than 14 days, and it extended up to about 21 days by their petition, which was on 6th of July. So this is their case. And their case was founded particularly on the provisions of the Electoral Act, particularly, Section 33 of the Electoral Act, Section 35 of the Electoral Act, and other provisions of the Electoral Act. But what the court held yesterday was that for you to be able to disqualify a candidate, that it must be hinged on the provisions of Section 131 and Section 137 of the 1999 Constitution. Justice Samani, while reading the judgment, stated that the provisions of Section 137, of course, covers all the disqualifying grounds for which a person can be disqualified.
To rejoin us back, some technical issues arise. Let's come back to studio. We know say yes, okay, yes, I can hear you. Okay, you are back.
Hello. I can't hear you from the studio, but then I'll just proceed. All right, thank you.
Yeah, I can hear
you.
Yeah.
When you look at the court held that by virtue of the provisions of Section 137 of the 1999 Constitution and Section 131, 131 provides for what qualifies a person .
Okay, I think Maxwell seems to be having some challenges and all that. So we will expect for him to come back so that we'll continue the analysis. But as we expect him to come, make we come back to studio. As we know, yesterday we packaged all the talks where they talk for there. We are on for more than 14 hours. We know how long it be from morning up till 10 p.m. And then we have the lawyers. Yeah, just a moment. Let's take a listen to what the lawyers said. Then you come back. Let's take a listen to what the lawyers said. Then we'll go back to Maxwell. The LP lawyers.
I'm saying that our clients are dissatisfied with the judgment just delivered And we have the firm instruction of our clients to challenge the judgment on appeal. And the court has promised us that possibly by tomorrow we are going to get a copy of the judgment. Once we have it, we will swing into action. Let me say this. We have to be very, very careful in this country. If we are not careful, electoral jurisprudence will virtually disappear. I'm saying this with every amount of sincerity, because when the litigants, when those who contested the election continue to find it very difficult to establish their case due to obstacles all the way, starting by INEC, certainly they may resort to some other means of trying to seek justice, which may not be lawful. And nobody encourages that. Nobody encourages that. So, and also, I commend the Court of Appeal for introducing live streaming. You will recall that we applied to the court to have live streaming of all the proceedings. The court, in its wisdom, did not grant the application, but now in the end, they saw wisdom in it to guarantee transparency. Hence, they introduced live streaming of the judgment. Certainly, it would have been better if there was live streaming of the entire proceedings, so that the public will now watch it from beginning to the end and connect properly with the judgment. But this one just started from the judgment, so they didn't start from the very beginning. So I do hope and pray that next time it will be continuous from the beginning of the case, beginning of the hearing, until the end. That is the only way you can ensure transparency. Because when something is open, people will see it themselves and they will make up their minds one way or the other.
Thank you very much.
Finally,
Okay.
I leave you with one word. History. History will vindicate the just.
We don't hear him as he intake talk him. That is Liviu Zoku, our own man will be say he did gallantly yesterday. Many people they sleep for inside court, but in no sleep. In listen well, in hear everything where they talk there. And I know say if to say then they confront those justices, in go confront them. But as we hear as intake talk, then don't direct them, make them proceed to the Supreme Court. But before they do so, then go collect all the original transcript of waiting happen. All that talk where they talk that yesterday. Maybe we hope say then go give them on time, because every time, everything they time bound. As I they always talk for here, this Presidential Election Petition Tribunal, then they work concurrently with INEC. Because there is no other way. Where they want all the whole evidence during the trial, they know do wetin they suppose. They even ask question, what you want make we do? Anyhow, make we go back to Maxwell. I think by now in line don dey stable, making for explanate, give us the summary of waiting in see for court yesterday, because no be only say in watch, in see with him own eyes, in there physically. Let's go back to Maxwell. Maxwell, you have the mic.
The judgment for the APM was largely based on that singular issue about the nomination of Kashim Shettima and the replacement, of course, of Kashim Shettima by or of Aminu Masari by Kashim Shettima. So what we have seen is that the court has ruled that for you to question anybody's disqualification, it must be founded on the provisions of Section 131 and Section 137. Now, there is something very striking. After that judgment, it was definitely known to everybody that, because this same issue was part of the Labour Party's case. And also, it was part of the Labour Party's case. And on that basis, that same issue was also, thrown away by the court against the Labour Party. So that is for the APM's case. Proceeding into the Labour Party and PDP's case, it beats my imagination that the court have decided to leave to do justice, but have decided to rest on the technicalities of the case. What is the intention of the lawmakers when they made the 2022 Electoral Act? It is to solidify our electoral system, to make sure that the fraud that goes on during election is curtailed or stopped totally. And by this, there was the technological innovation of the Beavers machine and the provision for a process of uploading results directly from the polling unit. On our way there for studio.
Well, I think Maxwell keeps off and on, and make we go for the grounds for this very Masari case when they even talk. That one APM case, then dismiss him, sake of say waiting Supreme Court talk before for the case of PDP where they carry go that very last year. Now then take Commodore very one. But before you go reach to explanate all the other things, make I foretell on waiting me, I think, for studio here. And mostly na technicalities now then they take work that very yesterday. So why would they expect make Maxwell come give his analysis of the whole thing? I want make we for talk our own small. Why would they wait? Make it, we know what in the throw and come out for where they talk maybe in a network. So Angel, how you take see the matter yesterday, because you did everybody did they watch the listing. How you take see I'm going forward for your own side? Say a few words, make Maxwell come back, make we listen the analysis.
Yes, now as you say, now technicalities, we believe them, and we even see ourselves, because the reasons where those justices they give, even jail. Because other cases where they refer them to, they know they even read them. How you go, which one yourself will go even talk? Because the whole thing, they gave you evidence. The evidence plenty. They no even look at. Because if they uphold this man now where they there, now be say every criminal go they come, forge certificate to bring and come. If you disqualify them, because they go take that judge back to this case. Now make we they shout and sense. They say judiciary are on trial. They no hear them because they are guilty. Now make they say make we bring the billboard down. Because this thing where they do yesterday, they just destroyed this nation called Nigeria. Because they didn't even judge it in through constitution. That is the issue, which means the constitution is not very relevant. Why would they judge it by their own making? Even one lawyer stand up, one talker, he say when you get to your own time as a judge, may he talk your own. Which means everybody can judge as they want. It don't make sense.
The something is that when you listen to everything that they were talking about yesterday, they dismissed out of the 13 witnesses that Labour Party brought and P2B, they dismissed about 10 of them. You understand me? And when they started that very matter from the initial hearing, they said that they were not going to rely on any technicalities, that they are not going to even entertain technicalities. Now, when they went to the judgment, basically everything that they talked about there happens to be about technicalities. But the worsening part of it is 25% of our budget.
That one now, they bring tears to my eyes.
That very 25% of our budget from yesterday's judgment, or call it false judgment, you will notice that Nigeria now has 37 states. You know, usually when we say Nigeria, how many states do we have in Nigeria? We say it's 36 states and FCT. You understand me? Now, there is one important word that that man that was giving that judgment used yesterday. They say jettison. I want us to see what is the word jettison. Can we go to the dictionary or to even Google to check what is jettison? That they don't, everything they said yesterday, they were talking about the literal meaning of the Constitution, the literal meaning, the normal meaning. That is, everything was going as a normal. But guess what? When it gets to 25% of Abuja, they say they are not going to use the literal meaning of it. That they are going to preface, that they are going to do this. And he used his own mouth to talk, say they are going to jettison. For here, we no go school, you understand? Because then be professors, you understand me, and all of that. But somebody will be say for comment section a day, make una help me check wetin be jettison. Now the justice use him mouth talk say then go jettison that constitution where they talk say then go they read constitution. Say the normal way of reading the constitution with its literal meaning when there is nothing to amend is to take it as they write it. He said they are not going to read it like that. As far as Abuja 25% is like that, that they are going to jettison it. I no go school. Make una go comment section. Make una tell me wetin be jettison. I dey wait. Esther, make I hear your own version of wetin you hear yesterday. Why would they wait for our Maxwell for Zoom?
Okay, still on the 25%. So now this 25% qualify Obasanjo. The 25%, what we know say will be the requirements before. We don't qualify so many presidents. You can't reach this time now. Salabi tell us say they inconsequential and even they irrelevant. The thing we say our judiciary system has been so much trampled. In fact, there is no more constitution. Our constitution has been buried. That is it. But no matter the matter, justice must surely prevail, no matter how long it takes. Okay,
I will go to Maxwell now, but I won't read wetin somebody they explain to me wetin jettison mean. As I talk here, when would they speak our pidgin? Now be say we no go school. So I will like make we send that to our people because we know even though be dirty family members and the TV,
yes, we get professors.
We get professor. We get people who say them pass professor. I say, what in they call the people who don't pass professor? We no know. But somebody where they here talk say jettison mean to throw or to drop something from an aircraft or ship, meaning say they won't throw away something where we say they for top, they won't throw up. Now the justice carry mouth talk during that time. I go pinpoint the area because I don't say that thing come for hours, but I go bring them for that place where we say we are going to jettison this very section from the literal meaning. You understand me? I will not forget this from the days of my life. Now, back to Maxwell. I know you are there. Please, let's try to summarize this, what that judgment they gave yesterday for our people to understand. I think the APM that you have talked about has been resolved. So maybe we should move to the PDP. And I think LP before PDP. Yeah. I think, yeah. Oh, Maxwell is not there back. I thought he's back.
His network is bad.
Network. My goodness. Anyway, we'll continue. So for our people, when we say una dey send una wetin una think una fit dey.
Sorry, Mr. Kanu. I for even ask that man, that justice wey talk that thing, which means you don't create new states for Naija now. Because you no go say we get 36 states. Because if you include FCT, now 37 now we get. So wetin happen to that and?
Okay, now let's leave that and, because that very and na be the thing where we dey talk since.
Okay, na be the
now
jettison wey dey throw away.
Court don come talk their own. See, another person wey talk for here, he talk say that jettison something is to reject an idea, belief, plan that you no longer think is useful or likely to be successful. Then he says synonym is abandon. See jettison in the Oxford Advanced Learner Dictionary. Now we no get dictionaries for here, but we know say almost 1,000 people dey here, and then fit talk wetin jettison mean. So this very jettison where we dey talk now, they use their mouth
abandon our constitution.
Wetin dem dey talk to abandon wetin dey for constitution. Now they use their mouth say dem go jettison am. Na so dem take talk. No be we dey talk. If they talk every other thing, we'll still come for the other analysis where Maxwell go bring for us, but we will go back to waiting the judges use their mouth talk. Say they go jettison that and. Meaning say they want to and comot from this. But again, they go back to the same constitution, say they go interpret the literal meaning of this, the literal meaning of this should be taken, but when you get to 25% of Abuja, they say they are going to jettison it, which means to throw it out. And so then they explain. If you know say you get another meaning, whereby, because when they say jettison, they don't mean like say if you there for jet, then you go do sin. But we will come back. Make we see wetin PDP people, their own lawyer talk. Make we dey wait for our analyst, make him come back, come break this very thing down.
The judgment has been delivered, but we have not received justice. Luckily, the Constitution has given us the right to go on appeal. This is a court of first instance, to go on appeal to the Supreme Court. And you see, this is a struggle that is not just for our clients, but for the Constitution of this country, for the rule of law, for democracy. For democracy. We were expecting an outcome that will improve, encourage the use of technology to enhance election management, to enhance transparency, to enhance accountability, so that Nigerians will believe in democracy. Nigerians will come out in their masses like they did to vote. We don't want Nigerians to be discouraged in the process. There are certain things, certain principles of law that we know that we need to explore, and we strongly believe that when we get to the Supreme Court will have the opportunity to review a number of things that have been said here today. So we have the instructions of our clients as soon as possible to go to the Supreme Court. So we have, today as you saw in court, we have asked for the records, we have asked for the judgment, we are going to apply for transmission of records because we have a very limited time to push this. So the struggle continues, and as it is said, it is not over until it is over. Thank you. Yes.
Okay, so we don't hear as PDP lawyers take talk their own. Now I see their face as it in the be, because even when they dey inside courtroom, na laugh and they watch Professor Mike Ozekome, wey we know say na professor of law. No be say na just son or something, na professor of law. So if una see am even for screen as we dey, when they do all those things yesterday, it's just they watch them like say na film, then they act. But anyway, sha, our own UC Maxwell don come back. Make we go back to am. Make we start from LP or PDP. Make we forgive the breakdown, summarize the things. Maxwell, let's go.
All right. Thank you very much. I don't know what is wrong with my network. I have been trying to see to solve the issues. I apologize for all the breaking transmission. So when you see, there were basically 4 issues that was placed before the courts yesterday, and the issues are central to the fact that the elections were not conducted in line with the provisions of the law. Now, when you say elections are not conducted in line with the provisions of the law, that INEC did not follow the Electoral Act to see that it conducted the elections. The petitioners had questioned issues of non-compliance with the provisions of Section 47, Section 60, particularly Section 60 sub 6, then also Section 64, subsection 4, subsection 5. And then they also based their arguments on the provisions of clause 38 and clause 48 of the regulations and guidelines of the election. So what beats my imagination so much is that after listening to all these arguments, calling this case, the court held that there is no place in our electoral jurisprudence that provides for electronic or that provides for the transmission of election results to a collation system. So please, producer in the studio, if you have the possibility, can you bring up clause 38 of the regulations and guidelines, and also clause 48? Let us look at it. Because the court looked us in the eyes and brazenly told us that the provisions contained in our laws, in our electoral laws, that there is no place it's made mention of collation system. And I shouted here several times that there is the provision to upload from the polling unit to 2 places, the IREV and the collation system, and it is provided there within the law. When you look at Section 64, subsection 4 of that Electoral Act, it says that before you will even start collating at the ward level, at any level of collation, that you must ensure that there have been an upload, and not just an upload, that upload was done to the collation system, and that you use that upload to verify the result even before you start to announce. So it's unfortunate that the court had this particular view about the electoral laws. Not only that, when you look at it, when you are talking about the interpretation of the provisions of the Constitution, the law states that you must first of all give it its literal interpretation, and if it will manifest any absurdity, then you can proceed to consult other modules or other means of interpreting provisions of the law. It beats me that the court, in interpreting the provisions of Section 134 of the Constitution, which provides for the requirement to get 25% in 24 states, and to also get that 25%, in the Federal Capital Territory. And it stated that it is not a requirement. It stated that the usage of the word "and" is not necessary in computing. And the court went ahead to interpret it that the Federal Capital Territory is now a state in Nigeria. These are the kind of judgment that has come out of the court, and people feel that we should not talk about this judgment. People feel that we should not argue about the merits of this judgment. I have said several times that a judgment can be said to be fair if right-thinking minded people can indeed determine that the judgment was fair. Another thing I like to say is that the court talked about, that the witness statements on oath of about 10 witnesses, which the petition has brought to the court, are not, were not front-loaded. Not only that they were not front-loaded, and on the basis that they were not front-loaded, that they were going to, throw away the evidences. It means that because of witness statements were not front-loaded, that all the documents tendered by these 10 witnesses were thrown away out of the court. That all the oral testimonies given by these witnesses were thrown away. The reason the court said for doing this is that the provisions of the Electoral Act, of the schedule to the Electoral Act, states that you need to front-load documents. You need to front-load witness statements on oath of witnesses which you intend to call. But let us look at the realities on ground when it comes to the front-loading of these documents. Number one, which is the fact that there is a period for which a person is to bring an election suit before the Election Petition Tribunal. And all these witnesses were brought on the basis of a subpoena, meaning saying a court give order, say, may them bring these witnesses. And the court said that these witnesses were the petitioner's witness, that it was not their witness. For you to bring a witness on the basis of a subpoena, the court needs to sign an order, which is called the subpoena, either subpoena ad testificandum or subpoena ducesticum, which is the subpoena to tender documents or the subpoena to come and testify. Something is very striking here, that within this period that a petitioner have to bring his case before the tribunal, the tribunal justices had not been inaugurated. So which justice, which judge of the Court of Appeal would have signed, which of them would have signed these documents, these subpoenas, to bring them to the court? So it means that there was no reasonable time, there was no reasonable possibility for them to even come to the court, ask for a subpoena, and then submit a witness statement on oath. So because of there were other witnesses that the petitioners duly had from their own end, they submitted the witness statement on oath of these witnesses. So it is not just about giving judgment, it's about giving the effect of the law. What is the of our electoral jurisprudence? It is to make sure that we have a free, fair, and credible elections in the Federal Republic of Nigeria. So anything that violates these principles of our electoral jurisprudence is not justice. We must note this clearly. So it means that we are giving leverage to anybody to make a mockery of our election jurisprudence. Let us look at the cases before the court. Now, I told you that they threw away 10 witnesses out of the 13 witnesses that were brought to the court by the petitioners. So it means every document that was tendered to prove all the reports that was tendered by the witnesses, the 18,088, papers which were blurred and unreadable, which were brought. How could INEC have given 18,088 blurred and blank papers to the petitioners to prove their case? How? And the court upheld this. The court did not reprimand INEC. The court blamed the petitioners. Remember that for more than 3 weeks, the petitioners continued crying to the court that INEC has refused to give it documents for which it asked. How can you blame a child that was beaten for crying? This is the problem we see in our laws today. The petitioners complained, and in the entirety of that judgment, the court did not deem it fit to caution these people. The court did not deem it fit to question the modus of tendering documents by these people. Because how can you give somebody who wants to prove a case before the court and you give the person blank documents? How does the person rely upon it? And the person later decided to rely on it to prove that there was indeed manipulation, that you did not use the correct result to come to, to what you announced. Because the law states that for you to even be able to announce, you need to collate. And for you to collate, you need to have a copy that has been uploaded, transmitted. It is a shame. It is a shame. Because what I saw yesterday was not judgment. It was not justice at all.
Let me take you back to that clause 38. Producer, can you please put back that very, from what you had yesterday, Justice Samani ruled on that very guidelines. And now we have clause 38 on the screen. And if you have it, you're looking at the screen, or you want me to read it out?
I can see it. I can see it from my end here.
Okay, because you requested for it, so he pulled it up. Because there's something you posted yesterday, which we have placed on a banner, and it's about what Samani ruled as regarding this guideline, this section 38. And let's have it back on the screen so that I say Justice Samani ruled that there is no existence of a collation system in the Electoral Act and the guidelines, and the petitioner failed to prove. You said, please, can someone provide clause 38 of the regulations and guidelines? So now let's bring that very clause 38 and guidelines. This is it on the screen. And as we can see, it is very clear. There is another thing you also mentioned that we also had as a banner. Before we come to this clause 38, there's another ruling they have that also has to deal with this very clause 38. Let's have that so that you take two of them on it. Okay, now this here, you said the court recognizes clause 38 of the regulations and guidelines, which mandates electronic transmission. They, however, do not recognize a collation system, as collation is done manually. You shouted, God, collation system is a place, not a process. So please do explain it. May our people understand this thing. Take a look at clause 38 while you do that.
All right, thank you very much. Now, when the court was reading its judgment, the court stated that there is no place in our electoral jurisprudence that allows, or that there is no existence of a collation system. The court also mentioned that the petitioners fail to prove the existence of a collation system. It is not the job of the petitioners to prove the existence of a collation system, because it is written in the law. The court went ahead to say that by virtue of the Electoral Act, that if a person must question an election, that it must be founded on the Electoral Act. By that statement, the court unintelligently tried to make mockery of the regulations and guidelines and the manual for elections. Because what I saw yesterday by that judgment is that the regulations and guidelines have no place in our electoral jurisprudence. That the manuals of elections of officials have no place in our electoral jurisprudence. What they also try to say is that the petitioners failed to prove an electronic collation. That was not the petitioner's case from the beginning, because it looks as if the justices think that a collation system is a process of collating results. But that is not the case. A collation system is not a process of collating results. Collating of results is done manually. We agree. But this is not the petitioner's case. The petitioners are saying that by the provisions of section 60, subsection 6, and by the provisions of section 64, subsection 4, it means that there was a possibility of an upload. So when you need to know where INEC is going to upload, you need to make reference to the regulations and guidelines. And then you now look at clause 38. Please, you can bring it up. And when you look at clause 38, it states categorically that once an election is concluded at a polling unit, that the only thing that is to be done was that the accredited number of voters will be sent to the collation system. That a pictorial view, a pictorial image of the results will also be sent to the collation system. And not just the collation system also, that they will also upload to the BVAS, to the IREV. It is there within the provisions of the Electoral Act. So, of these regulations and guidelines, it is on the screen there. Anybody who have a PDF or can go online and search for these documents. I'm not fabricating these documents. So for the court to come back and tell us that there is no existence of a collation system, no, it is not the petitioners to prove the existence of a collation system, because INEC said they will provide a collation system. The law says that there is a collation system, and INEC have the duty to upload to that collation system. So there is nothing that needs to be proved. Anything that is provided in the law is already expressed. It needs no further proof. Remember that through our witnesses also in court, they tendered videos, they tendered memos, they tendered letters where INEC, they tendered newspaper publications where INEC had stated categorically that it was never going to go back on its promise to upload electronically. And that upload was to be done to the IRF and the collation system. These things are evidences before the court. So for the court to now turn around and tell us that collation system is a process of collating and that it is done manually is actually a slap on our electoral jurisprudence. I take every responsibility for the things I say on this platform. And I say it good. The laws are there that you must upload, you must transmit, you must transfer to a collation system. You must also upload, transmit, transfer to what? To IREV. The IREV is for the public to view and follow. The collation system is, it will now send you back to section 64 sub 4 of the Electoral Act, so that whoever is the collation officer that wants to collate and announce a result must check that what is uploaded in the collation system is actually correct with the hard copy that they have in hand. It's as simple and as short as that. And I'm sure that it was actually a wise decision for, you know, the Labour Party, the Peter Obi and the lawyers to decide to appeal this case, because there are a lot of lacunas in this particular judgment. I can say for free.
Okay, Maxwell, thank you for that very one. As you explain it, give us. We'll come back to you, but maybe we'll come back for studio because we get Angel with the prompt since where she won't put mouth for the matter. As they don't talk, say, Abuja and another states for Nigeria. So it be like say we no go the talk say na 30 states
yes,
we get.
Na 37 we get now. Okay. And they go they do election, may they get governor for there. Okay. Because we don't need ministers there now. Now governors now we need, and commissioners too now we need. Yeah. Because you can't say that one is jettison when you like. Then when you know like, you bring them back. I think it don't make sense. I think because the thing just, I don't know whether na verse Abina, the thing Abina, they see over 200 million Nigerians as mumu. Even people who no go school know waiting behind. And we don't they talk and since they talk and since.
No, na them be caught and they don't talk say then go jettison and where would they talk? And you and me, we don't understand the grammar. That's why we ask.
Okay, now where obedient or where meaning Nigerian don't find the meaning. They think say we no go find the meaning of jettison.
No,
I be the now then write the grammar.
Now, as we don't hear waiting be jettison, they say na to throw away. You understand? So that and where they there, they don't say no they useful for inside constitution.
Because so of one person. Because of one person, they turn constitution so, Esther, upside down.
I see say your mother they do me. But before you talk, make we hear from Princess.
Okay, yesterday, the judges just made a mockery of themselves because the law states categorically that 25% of FCT is mandatory.
Exactly.
And they, like they said, jettisoned it. They just chose the part of the law that suits them, and then the one that doesn't suit them, they will discard it. The man, I remember him saying one part of the constitution that says that they will regard the whole of the federation as one constituent. How are you regarding it as one constituent when in the same constitution it states that there are 30 states separately and this one is one of its own and FCT? Now you are discarding that one to choose the other part that is telling you it is one constituent. They will take the whole of federation as one constituent. All of a sudden it's now one constituent and no longer separate. Okay. They are making the law look like a joke.
Okay, before we come to Esther, I get one para where I see say Maxwell, the para yesterday where they for court. Because plenty things, they happen for court that very yesterday. But you know, say, waiting with the show, now waiting they happen inside court. Make we even see that Maxwell para where we say then they do an interview for outside. In the here now, if it explain, give us waiting give them high blood pressure, the vexation where they there. Make we take a listing from that very side first before we come back to Maxwell.
Judiciary do the right thing. We don't come here come fight. The facts are obvious. Obi wins the election. Even the woman when they stab for eyes, he go through the self-come vote with Obi. And so Luoma was opening threatening people not to vote. He said not to cancel the election. So if they are saying that Obi did not win, cancel the election. That is my stand. Obi won this election. So nobody don't get 25% in FCT. So nobody don't get drug case. Only in don't get results. Only in get dual citizenship. And yet you want to declare him president. We will revolt against it. We cannot be refugees in our own countries. They are citizens and not refugees. Me personally would rather be a rebel than a slave in this Nigeria. Declare to be the president and let's have peace.
Referred to as the most populous black nation, that the very, very essential of a democracy, which is free, fair, and credible elections, cannot be upheld in Nigeria. Why can't the people decide who rules them? Because the definition of democracy says that it is the government of the people, by the people, and for the people. So if the people cannot choose who is their leader, we don't have any democracy. All we are asking from the judiciary is very simple. It is justice. All eyes on the judiciary is just a slogan for justice. Both the executive, the legislature, and the judiciary, they are all arms of government, and they are subject to criticism from the people, because Section 14 of the 1999 Constitution states that the authority and powers belong to the people, and the people give it to the Constitution, who give it to these people in government. If the people have said we don't give you our powers, we have collected it, and we decided who we gave those powers on February 25th of 2023, and it's unfortunate that it was stolen. We will get back this mandate, and believe you me, we are not tired, we will not stop, we will not cower, we will not run back into our shells, we will only be stronger by the day. Thank you very much.
If I may ask you a question, Chief, no later. My name is Baba. No later. Yes. Come. Yes, you. You are not the only one making this. After that, party supporters are also saying that their candidate validly won the election. APC supporters are even closer to the court, where they are saying that the court must affirm their candidate as the rightful winner of the election. So what makes your own claim? What makes it different?
Now, it is very simple.
Your presidential candidate and his team of players have had their time before the tribunal, where they have had the opportunity to present their case. And if you have read the conclusion of their closing statement, your candidate or the Labour Party was not able to, did not tell the court that he won the election. It already didn't tell the court that he won the election. He only said that Tinubu was not qualified to contest and that the election should happen. So what do you have to say to that?
All right.
Yeah, so Maxwell, you see, you know the questions where they ask you for that very place and the kind of vexation where they are around outside the court. So it'd be like saying outside the court premises, this won't happen. Make you tell us what in they happen as we see say everybody where they outside the court be like say then the verse for maybe waiting they happen inside the court. Can you give us a hint of what happened there?
Right, thank you very much. The lady you saw in that video actually came down from, I think, Edo State to be in Abuja for, this judgment. And she was utterly disappointed, just like I was. Now, what you saw transpired there was the situation outside of the courtroom. Although the police had barricaded everywhere, preventing people from even going close to the building. And as if they knew that they were going to, give such a judgment, even in the live broadcast that they did, they didn't even show the faces of the judges. But of course, we know their faces, and we can attribute whatever we feel is our grievances to, the justice or the judgment that they gave. But you see, like I said in that video, many things I said there are things that are still valid even until today, which is the fact that our electoral jurisprudence, our electoral system, people who are in the temple of the courts of justice, who are ministers in the court of justice, people who are in executive powers, who are in legislative powers, have made sure that anybody who loses election cannot be able to win back their mandate. Not even lose the election. Anybody that they manipulate the election, they made it very impossible to win back their mandate. Because I find it actually insultive for the justices to say a lot of things about the petition. It was more like they were condemning the petitioners. It was more like they were flogging the petitioners for bringing the petition before the Election Petition Tribunal, for not getting all the documents, because that was what the justices were saying. But they requested for these documents from INEC. INEC failed to give them these documents. Several times, several letters were written. The problems of the justices is the fact that the letters were directed to the national body of INEC and not to the state, coalitions, or to the state, election offices or electoral offices. But we must understand that these things were said in court. Petitioners approached them at the state level, and the national gave an instruction that all documents should be submitted at the national level before they can obtain documents. These things were said in open court. I recorded it. I took notes of everything that happened in court. So it is actually funny that we have decided to go against the provisions of the law and go with what we think is just. That is not justice. That is not fact. By virtue of the laws, it is clear that the INEC, who had a collation system, who had the IREF, who told us that they were going to upload and failed to upload, the onus was on them to prove that indeed that there was no collation system, that there was no IREF, that there was no possibility of uploading. Because how could you have uploaded to the Senate for the Senate elections, you uploaded for the House of Reps elections, but couldn't upload for the presidential? And do you know that this number of election results are actually more than the presidential? It's more than the presidential. Because from the Senate and from the House of Reps, that is 2-1. Meaning that whatever number is uploaded for Senate and House of Reps doubles the presidential. So if the network can be able to handle that of the Senate and the House of Reps, why couldn't it handle the presidential? These things are logic. You can add 1 + 1 to get 2, for heaven's sake. It actually, you see. I feel like we are not getting it clearly here. That we are not going to court to know who is a better lawyer. We are not going to court to know who has the prowess of tendering documents or of shouting on top of their voices. We are going to court to determine whether an election was properly conducted, whether the person who was given power is indeed who the people wanted to have power. Because by section 14 of the 1999 Constitution, power belongs to the people. I said it in that video that you played. Who attains any office that is not given power by the people and gotten there illegitimately, I must be removed. Section 1 of the 1999 Constitution is clear that nobody must hold any power that is not duly given to him in line with the provisions of the Constitution. The Constitution has stated that in every way, INEC has the authority. Then the Electoral Act gave INEC the authority also, and INEC went ahead to provide for the regulations and guidelines. And you go back and forth. You cannot approbate and reprobate. You cannot deny, affirm. If you have told us that you will do this, you cannot change the goalpost in the middle of the game. It is never heard of. Because we are beginning to praise what will become a problem in our jurisprudence going forward. What they have done in the court is to take us back to the years of 2010. In 2010, there was no technological system. And for the court to tell us that it is INEC that should decide whether they should upload or not. Nobody is questioning INEC's decision to upload or not. But if INEC has told us that this is how they will upload, this is the method that they will use in the beavers, they spent monies. Come on, let us be realistic. The Senate brought out monies, taxpayers' monies, for INEC to conduct this election, for INEC to pay for beavers' machine. And you turn around and tell us that the purpose of the beavers' machine is not important.
Come on, we need to be going forward instead of going backward. And I will say this for those who feel that people are not meant to talk about judgments. It's a problem in Nigeria. And except judgments are subject to criticism by the people and even by the media, we will never go forward. We will never move ahead. Thank you.
Yeah, thank you. You talk well. For people who be say they think say as in don't put judgment, say we no go talk about that one a mistake. Because we always say that our eyes are on the judiciary, and we say that judiciary is on trial. Meaning simply say yesterday we didn't do that, they no say then they're on trial. But before I let you go, Maxwell, you get something where people talk, where people they wait. Make him for carry mark go begin the broadcast them or make it for tweet them where you no need to tweet, but it don't say in different ways. Now up to us where we say we be well-meaning Nigerians and obedience. Make we even hear as intake talk for just very few seconds, no be even 1 minute. Let's take a listen, then I'll come back. What you think about waiting in talk?
We've passed the time of praying. It's not going to be solved by praying alone. It has to be solved by acting. If you like, pray with discipline for the rest of your life. They'll never go away. You must chase them away. So they're not people you remove by prayers. So it is time to act, not to pray. The youth, unfortunately, you know how Marcos left office in Philippines? Marcos left office because on a Sunday, Cardinal Sin finished church service. Instead of saying, the mass is landed, let's go. He told everybody today, follow me and block the presidential lodge. After 3 days, Marcos and his wife left. It is time for us to close the church and deal with discipline.
So as we hear our PO take talk, prayer alone cannot remove bad leaders. Prayer alone cannot change the justices, even the justice of the Supreme Court, where would they go? Now actions where we say go take. Now Maxwell, finally, which actions you think say citizens will be saying now well-meaning Nigerians fit take now will be say this judgment don't come out and we know say waiting they write or waiting they read out for us now like waiting they won't tell us say what you won't do make una do. Tell me from this PO's perspective, it is in our hands. It is no longer about prayers. What do you say about that?
Much for that question. You see, I want to say this, whether you are a Muslim, you are a Christian, you practice Hinduism, you are a traditionalist, you whatever religion you may ascribe to or you are a believer of, I want you to understand that there is time for everything. There is time for everything. It's unfortunate that our people have decided to use the time to act, to pray, and there is time to act. Before you go to your office every morning, you have a duty to resume at your office by 8 o'clock. Do you use it? What you do is that you use 6 o'clock to say your morning prayers, and you step out to be at the office by 8 o'clock. So, we should not continue to rest on prayers. We should not continue to rest on, not continue to rest on these things. I'm not saying that you should stop being a Christian. No, don't get me wrong. I'm not saying that you should stop believing. No. But when future and you decide to stay back, we prayed before this entire movement started. We prayed before the judgment. So what stops us from acting? A person who is praying and does not have a PVC is a... Because even your word says, except the righteous are in power, the people will suffer. So if you don't have your PVC to choose who is your leader,
You are only going to pray in futility. It's not going to affect the exchange rate. It is not. Let me tell you something. Those who prayed and those who do not 20 naira. Is that not so? As of yesterday, Mr. Kanu, yesterday night, are you aware that there have been an over, I think, 40% increase in electricity tariff? Not pray, you will pay the money for electricity tariff. So these are the realities that as a duty on us, even as Christians, Muslims, whoever you may be, you have the duty meet to your civic duty of choosing who your leader should be. Because if you don't choose your leader, somebody else will choose it for you. And after they choose it for you, whatever you take, you receive. What if you continue praying, you refuse to vote, and somebody comes into power and say that your religion is no more accepted in the country? What will you say about it? You cannot do anything. So these are the realities. We should know that even as Christians, even as Muslims, whatever religion, traditionalists, whatever it is you ask to, I'm a Christian, I must say that my religion allows me to play my civic duty. It is my duty, even as a Christian, to see that the society where I live in is affected by good governance. Thank you.
Okay, thank you very much. Our time don't they give us signal. Signal be make we carry our car come out for studio. But before we come out from studio, we want to tell everybody where they here. Make una for like and share the video, and then some people say make we forget meeting, discuss waiting PO they talk. His Excellency P2B, he they talk something for this very video where we watch. As now they won't begin the proceed, they go Supreme Court. I want make everybody know, make we get meeting. And this evening, now I want make we get this very meeting. I go send the link in for our platform, and I want make this evening, once we go live, if our platform no fit contain everybody for Zoom, but make other people. And for people who join us for Zoom, where they there, I get our own Dr. Chioma, all the way from US. They expecting say go raise your hand. Okay, don't they raise your hand since make say okay, then they show me waiting our people they talk, but I go want make we have meeting because me I know they see clear reach that very side. So all our people wait there for Zoom where be say I know if you reach their destiny. Somebody said he has something to say. Destiny Chigozie. Okay, let's hear you quickly, please.
Yeah, can you hear me?
Yes, we can hear you.
Good afternoon, everybody. You know, it was really sad to me when they are not judges. Let me use it that way. Because if truly they are judges, they could have looked from their conscience, go straight to the point, not beating around the bush, changing ways, which is not normal. Because what I came to understand here is that, assuming their children are facing the suffering in Nigeria, they could have do something. Now, they judge according to their will, not according to the will of the masses. And those of the children are not at home. Because when you give judgment, you wait for the consequences. When you give law, you wait for those that the law will affect. Now, many things I'm seeing. Bible said, because somebody said we have to put Christianity aside. No, there's no way for us to put Christianity aside. Because in those days, leaders, there was war, even Christianities. Whatever they want, let us do. But the issue is that who are we fighting? It's still Nigeria. These people that did this evil are not in Nigeria. So what am I trying to say is that, like all these justices, my own opinion is whoever that knows wherever their children is should have a target. Because I'm not trying to be a racism or whatever. But let us be realistic. Because when we are fighting now, we are destroying our properties, we are destroying this, we are destroying that. Imagine that the common Smith who Nigeria is selling 6,000, while other countries is selling lesser. Things that Nigeria is supposed to do within themselves, they didn't do it. Fighting themselves, why they are allowing leaders to be oppressing us. So it does not make sense. What I'm trying to explain is that let us not fight ourselves in this matter, because there is still hope as far as Supreme Court is concerned. Let us wait for what Supreme Court will do, because the moment, because that's what the lawyer said, that during the case they refused to show it live. Now during the ending they show it live, and which is very wrong. They're supposed to show it live from the beginning, so everybody will not have the point. Though they show it, they didn't show it live. Even the estimate know that this judgment is not normal. So you get the point. So what am I trying to say is that let us not fight one another at this moment, because you fighting your fellow brother now, it does not make sense at all. Let us wait for the Supreme Court before everything can be destroyed.
I don't think we even wait. Now the lawyers go begin, they go Supreme Court. We will go begin to ask questions, and like PO take talk, we need to put ourselves together and know and talk about this very judgment itself. You know, to them, what they have done is business as usual, but it is not business as usual for us. You understand? That is what happened yesterday. As for what you said about the lawyers' timing, yes, it's good that they showed the video, live stream what happened yesterday. But as you notice, they did not show their face, as Maxwell explained. They just want to show what happened. But the important thing for us, we have heard them. It's not really about their face, but hearing them that is important, and what they thought. So that's why I said to them, what they have displayed is business as usual. And now that we know, we need to regroup. We need to think why the lawyers do their own work. Their own work is to go to Supreme Court and present what they have done on this side. We, that PO is representing them, because it is our mandate. It is not his mandate. So if he says, well, we are taking this matter to Supreme Court, yes, the lawyers who are to go there will go there, but we need to speak out loud in one voice. And that is what that very video of Peter Obi speaking is telling us to do. And that is why we said finally, as we are going off the studio, that we are calling for a meeting which will go from a show. We open up the line for people to choke their mouth inside on going forward, because we need to regroup. If we did not do that, then it means that we have accepted that our mandate that is stolen should go, because we are the ones that have this
the pain. Who know that we should know where the pain is. Exactly. Okay, thank you, sir. But the issue that whatever would have come out, everybody should be still remember that we are still brothers, because these people that did this is not with us. Because if they are with us, you see suffering in Nigeria, you're supposed to be going back of the corner and be saying what pleases you and not what pleases masses. Even where we are.
Anybody that gives up now, Chigozie, anybody that gives up now is not an obedient one. Anybody that hangs up now is not even a well-meaning Nigeria. The battle is for the soul of Nigeria. It is not about Peter Obi. It is about what these people take us for. Whatever time, whenever they want to change. Okay, if they had wanted to say that it's about turn by turn, I mean, they can just change the constitution, make it very clear from National Assembly that it's turn by turn. I mean, we know that Tinubu started it, it's turn by turn. But if it's about the vote of the people, then the people need to rise up. With that one, we'll go close up today because time don't give us signal. We'll come back later, make everybody there ready to join us, call in and express yourself and how we are to moving forward. With that one, I go come back to studio and give Angel the mic, make we for quickly this thing. But I know if like as we talk, make on a like and share so that other people go know say Obidati Family TV is still there and the hope still there alive.
My lovely and intelligent, obedient worldwide, history will vindicate the just, no matter how they try. Yesterday, they just turned the constitution upside down. But I just pity them and pity their generation. Because in 10 years to come, they will be so ashamed of themselves. Even their grandchildren will be so ashamed of them. Oh, Grandpa, you did this to your own country. How do they even sleep? How? The money that will finish in a year or two, you sold all the rights, all the things. Over 200 million Nigeria went out on 25th February to vote for their own people. Because the hardship is too much, you just put the whole thing down the drain. Even our witnesses, LP witnesses, you say it doesn't matter what they are talking because they are LP members. But Bamidele, that is a witness for Tinubu, you uphold his own. What are you people doing? They say court is the last hope of human Is it? Last hope for the masses, is it? It's not. It's not. It's not. My heart is bleeding. I'm very, very angry. Verse, don't they kill me here. But no wahala. Like, share, and subscribe. Like, make every obedient. They hear wetin dey happen. So that we'll get our strength and force back. For make we know whether Supreme Court go do the right thing where appeal no gree do. Abi whether they go still sell Nigerians, give to the highest bidder. We go know. Like, share, and subscribe. We appreciate you. We love you. But God loves you more. Bye for now.